We have had the coin toss. Kendrick won it. They have determined that they will go affirmative. We have Anderson Lyle from Apollos. You will go negative. Perfect. Okay. I'm going to welcome to the stage Ms. Patsy Buttman, who's going to introduce our judge panel.
Okay, we have a great panel of judges lined up, of parents, alumni, and community. On my left, I have Mitchell Brisbane. Okay, welcome Mitchell. Mitchell is the oldest of two kids who debated for 6 years in competition, including experiencing NITOC, correct? Okay, and he is a junior political science major at Middle Tennessee State University with aspirations for law school. Next to Mitchell, Carlita Boyles. Carlita has been married for 25 years, has 4 children. More? 7. 3. Okay. I'm seeing, okay. She has children, and one is still competing in speech and debate. She has a master's degree in special education and is a specialist with learning. She taught special education in the California public schools and is author of Math on the Level. It's a homeschool math curriculum. Next, we have Michael Miller. Michael, would you take a stand, please? I'm now going to introduce our community judges. Thank you, Michael. Michael received his BA in Bible from Bob Jones University in 1986. After attending seminary and working on staff at BJU, he attended the University of South Carolina School of Law and received his JD in 1995. He practiced business law and general litigation in Columbia, South Carolina, and taught business law and corporate ethics at Webster University. He is currently the executive assistant to the executive vice president for academic affairs at BJU and Title IX coordinator for the university. Let's give Michael a hand. Next, we have Randy Page. And Randy, if you would please stand. Randy serves as Director of Public Relations for Bob Jones University. Prior to serving at BJU, Page served as president of one of the largest grassroots organizations in South Carolina and served in senior staff positions with both the governor's office and the lieutenant governor's office. Page was delegate to the 2012 Republican National Convention, served on the RNC Platform Committee, and as a member of the Electoral College. Additionally, Randy serves as chairman of Page and his wife, Melissa, are active members of Faith Baptist Church in Taylors. Also, the STOA board wants to give a heartfelt thanks to Randy for working alongside us since February to recruit community judges. We couldn't have done this job without his service. Tony Bean, if you would please stand. Tony is Vice President for Student Services and Christian Worldview at North Greenville University. He is host for Christian Worldview Today, heard Monday through Friday on Christian Talk, 660 AM and 92 FM. Additionally, he is the interim pastor of Cud Memorial Baptist Church in Bowling Springs, South Carolina. Other titles for Dr. Bean include Chairman of the Christian Life and Public Affairs Committee of the South Carolina Baptist Convention and board member of the Palmetto Conservative Alliance. Tony is married to Denise of 35 years, or for 35 years. They have 3 children. Adam and Allison, and 4 grandchildren, Caroline, Lucy, Henry, and Jackson. Why didn't just a few of us get the 35? Okay, the STOA board would like to publicly thank Tony for his support in advertising the NITOC 2015 tournament to the Greenville community for the past 6 weeks. We also want to thank his colleague, Josh Kimball, who also took part in that. You've seen the signs for his radio. We literally had judges walk in this week saying they'd heard the announcement from his radio. So we really, really appreciate you guys. Thank you so much. It's also been a joy to work with all of these people because one of the first comments out of their mouths was when they were asked to help is, we believe in what you're doing. We believe in today's youth. And that's just been amazing. Okay, then Suzanne Myrie from Tennessee. Suzanne is married to Kevin and mother of 6. She has a BA from Central Michigan University and an MA from Southern Illinois University. Illustrator and coach for Momentum Debate and has done that for 7 years. She's very excited to promote and watch STOA grow throughout the USA. Debate and speech are the best finishing touches to any educational program. That's from Suzanne's words, and I agree. Okay, then next. Dan Hamilton, if you would be stand and recognize. Dan was elected to the South Carolina State House in 2008. He represents District 20 located in Greenville County, which includes parts of Taylor, Greer, and Greenville. Dan is a majority whip in the House and serves on the Labor, Commerce, and Industry Committee and the Rules Committee. Outside of his service in the legislature, Dan is the managing partner for Keller Williams Realty in Greenville. He led his company from startup in 2003 to now being one of the largest and most productive residential real estate brokerages in the state. Prior to his real estate career, Dan worked as a legislative aide to then Republican Jim DeMint, who later went on to become a United States Senator. Dan met his wife Kelly in college, and they've been married for 16 years. Together, they have 4 children, ages 13 down to 3. They are members of Heritage Bible Church in Greer and reside in Greenville. Thank you. And then Susanna Greer, our final judge from the community. Susanna is an experienced special educator and school administrator. For 14 years, she has taught dyslexic students to read and write. She is currently the head of the Language Development Tutorial Program at Camperdown Academy, a specialized school. Mrs. Greer is a fellow of the Academy of Orton Gillington Practitioners and Educators. In this capacity, she trains teachers to use multi-sensory strategies in language classrooms and individualized lessons. Mrs. Greer is an alumni of the Governor's School of Science and Mathematics, and in 2014, Mrs. Greer received her master's degree in curriculum and instruction from Furman University. She and her husband are members of Redeemer Presbyterian Church. Thank you. And then Steve Vaughn. Steve is has one wife. Sorry. I am reading this on the fly. And 6 children. That's good. Okay, he's a registered nurse with a degree in philosophy, and he is a small business owner of a nursing business and also a small coffee roasting business. He is has been a speech and debate coach for 8 years and was originally recruited as a community judge 10 years ago. Wow, that's great. Okay, and then Cody Hirsch. Cody is the third of 5 boys, all of whom competed in high school homeschool debate. He has his JD from Cornell Law School and is a law clerk to the Honorable Richard C. Wesley, United States Court of Appeals for the Second Circuit. He is also author to Cross-Examination, Keys to Cross-Examination, 2006. Let me back up. In 2006, you were the teen policy debate champion. Is that correct? Wow, congratulations. Thank you. And then finally, our president of STOA, Dr. Van Shalen. Sharon is married to Susan of 31 wonderful years. He has 2 children, Andrew and Claire, who both competed in high school speech and debate and also in college. They did it a total of 6 years. He is a doctor, an emergency room physician, practicing in the second busiest emergency room in California. He has been a longtime TP coach and has coached a winning team to the national championship. So, thank you very much, and I hope these kids behind me really challenge you. I hope it's a tough decision because we've got some great teams behind me. Thank you.
Hello, my name is Kyle Kendrick, and I'll be your second affirmative today. Thank you all for judging. Hi, my name is Matthew. I'll be your first affirmative. Thank you very much. Jack Anderson, first negative. It's a pleasure.
Jonathan Lyle, second negative. Thank you very much.
Is everyone ready? The Electronic Frontier Foundation reported in October of 2014 that by using NSLs, or National Security Letters, the FBI can directly order companies to turn over information about their customers and then gag the companies from telling anyone that they did so. Because the process is secret and because even the companies can't tell if specific NSLs violate the law, the process is ripe for abuse, unquote. Because national security letters violate our country's law of the land, the United States Constitution, my partner and I stand strongly resolved. The United States federal government to substantially reform its electronic surveillance law. The Constitution keeps our government accountable. It outlines all of our rights as citizens, and it gives a complete list of all the things that we can do and the rights that we have. And it's for that reason that the criterion for this round shall be that of the Constitution. Criterion of the Constitution. Whichever team best upholds America's law of the land shall win this round. With that in place, let's turn to the background points. Background point number 1, you can write down as National Security Letters, or NSLs. That's National Security Letters, or NSLs. Subpoint A is how it works. Subpoint A, how it works. The Electronic Frontier Foundation reported in October 2014 that a national security letter is a law enforcement investigative tool issued by the FBI. They allow the FBI and in limited circumstances other federal agencies to demand that companies turn over data about their customers' use of services such as banking, telephone, and internet usage records. Unquote. In other words, the FBI forces corporations to turn over customer records through means of a subpoena. Subpoint B is the numbers. Subpoint B, numbers. The Electronic Frontier Foundation said in 2014 that over 300,000 national security letters have been issued in the past 10 years alone. The most NSLs issued in a single year was 56,507 in 2004. In 2013, President Obama's Intelligence Review Group reported that the government continues to issue an average of nearly 60 national security letters every single day. Let's turn over to background point number 2, which you can write down as administrative subpoena versus judicial subpoena. Background point number 2, administrative subpoena versus judicial subpoena. Now, the founding fathers created different jobs for both the executive and judicial branches of government. One of these jobs involved the gathering of information for a judicial review. That power was handed to the judicial branch by means of a subpoena. However, national security letters are usurping this power and getting administrative subpoenas. This comes from Michael Doyle in the McClatchy Washington Bureau in 2014. He says, quote, national security letters are a form of administrative subpoena issued without court order. Background point number 3 is gag orders. Background point number 3, gag orders. The Electronic Frontier Foundation reported in 2014 that the 4 NSL statutes all include gag order provisions barring those who receive national security letters from disclosing the fact that they have received such a letter, even to the consumer whose records are being sought, and from disclosing the records provided. Basically, what this means is that attached to the letter that you receive is basically an order from the FBI telling you that you can't tell anybody that you've actually received a national security letter. With the background cleared up about national security letters, let's move to the harms. Harm number 1 is First Amendment violation. Harm number 1, First Amendment violation. This comes from the Electronic Frontier Foundation, who said in October of 2014, at the Second Circuit Court of Appeals and the District Court for the Northern District of California have both ruled that a national security letter gag order amounts to unconstitutional and content-based prior restraint on speech, and that the statute fails to include procedural protections required by the Supreme Court to protect First Amendment rights. Essentially what this means is that the gag order provision attached to the national security letter harms your freedom of speech because you're not allowed to tell anybody that you've actually received a national security letter. Harm number 2 is separation of powers violation. Harm number 2, separation of powers violation. This comes from Bob Adelman, who said in March of 2013 that the suit claimed that the FBI's letter was unconstitutional under the First Amendment's guaranteed right to free speech, as well as under the principle of separation of powers, in that information was demanded without a court order or probable cause search warrant issued by a judge. This is the idea of administrative subpoena versus a judicial subpoena. The executive branch, specifically the FBI, should not be able to order national security letters. Harm number 3 is no oversight. Harm number 3, no oversight. Specifically with regards to national security letters, the FBI is really not accountable to anyone. This is according to the Electronic Privacy Information Center in 2014. They say, quote, the report further stated that violations are supposed to be self-reported by the FBI to the Intelligence Oversight Board. During the 3-year period in question, the FBI self-reported 26 violations out of the 140,000 national security letters issued. The Office of the Inspector General, however, found 22 potential violations out of the sample of 293 NSLs reviewed. The Office of the Inspector General has stated that there is no indication that the 293 national security letters it reviewed are not representative of all of the national security letters issued, thus indicating that the FBI is failing to self-report a very significant number of violations. This leads me to the impact of lawlessness. Lawlessness. National security letters directly violate the law and should be voting for the Constitution in today's debate round. For that reason, we would like to offer the following plan. Congress will pass and the President will sign the following mandates. Mandate number 1, abolish national security letters. Mandate number 1, abolish national security letters. The United States federal government, through an act of Congress, will abolish national security letters authorized by 4 current federal statutes. Agency and enforcement is Congress, the President, the FBI, and any other necessary bodies of the United States federal government. Funding, no funding is necessary since this plan is legislative action, but any unforeseen cost will come through congressional allocation, and timeline is immediately. Let's turn over to a final solvency point, showing you how there will be no harm to security. You can tag this to solvency point number 1. No harm to security. No harm to security. The information that national security letters collect is not pertinent to national security and will not harm the FBI's ability to track down criminals in any way, shape, or form. This comes from Julian Sanchez, research fellow at the Cato Institute, writing for Just Security based at the New York University School of Law. She says in January 2014, that the absence of broad NSL powers prior to the Patriot Act does not appear to have been a major factor in the failure to detect the 9/11 attacks. And the public has not been made aware of any cases where such easy access to sensitive information has enabled the discovery of some plot or terror cell that would otherwise have gone undetected. The claim that the FBI cannot investigate effectively without a tool that has existed in its current form for roughly a decade should be seen as an extraordinary one, demanding equally extraordinary evidence before we accept it. It is for the constitutional violations that the national security letters present. I urge a vote for the affirmative. Thank you very much. No, you can't. It's all right.
All right. Congratulations on getting the finals.
You too.
So can I have a copy of your 1AC?
Absolutely.
All right. So specifically with the gag orders, are gag orders attached to every NSL letter?
The majority of them, 97%.
Okay. All right. So now what courts have ruled on the constitutionality of
The
NSL?
Second Circuit Court of Appeals and I believe the Ninth Circuit Court of Appeals, that was under part number 1. Actually, the District Court for the Northern District.
Okay. So a district court and appeals court?
The Circuit Court of Appeals, yes.
Okay. Do you have these decisions?
Not the actual decisions. My mom wouldn't let me print it off. They're kind of lengthy,
That's
but I think we can
understandable.
give you summaries of them.
Okay. All right. So with the Second Circuit, was that it? Did that ever get appealed to the Supreme Court?
I don't believe so, no.
Okay. All right. What was their decision? Did they stop the NSL use?
They stopped the NSL use within that district, within their jurisdiction.
Within their jurisdiction. Now, do you have evidence of that?
We can bring up evidence later if you press the issue of inherency. We also have pieces of evidence discussing how the FBI will continue to use national security letters because of the issue of statutory law versus common law.
All right. So the only agency that uses the NSLs.
Basically, yes, there are very rare occurrences in which other agencies will use them. We are stopping all uses.
Okay. NSLs are basically subpoenas with gag orders, right?
That's correct. Administrative subpoenas with gag.
Okay. All right. Great. So now, under your harm to that of the separation of powers, you said that the government argued that it destroyed separation of powers.
That's
Now,
correct.
did the court agree with them?
Yes, the court did agree.
Did it say that in the evidence?
I can bring up more evidence. You press
Okay,
the
but
issue.
as of in your 1AC, the court you read that the argument was that it destroys the separation of powers.
That's correct. The argument is that it destroys separation of powers.
Now, was this the district court or the appeals court?
Which court are we
The
talking
circuit court, or was this the district court?
I'm not quite sure.
Okay, all right.
We can
So you're
bring
not
up more
super.
evidence. We can talk about it.
Okay, but you do know they ruled in favor of the
Essentially,
opposition.
yes. Under
Okay.
my first piece of evidence, we discussed how the district court for the Northern District of California ruled that through First Amendment violation and a separation of powers violation, national security letters were unconstitutional.
Now, your plan simply stops the NSL use, right?
That's correct, yes.
All right. Does it provide any alternative?
No, it does not. There are no alternatives needed.
No, there are no extra restrictions, right?
No restrictions.
Okay. Are there any extra restrictions? Just ending the NSL use, right?
That's correct, essentially.
Okay, all right. So where are these authorized in the statutory
The
code?
main one is the Electronic Communications Privacy Act, or ECPA.
Okay, so in the ECPA, the FBI actually gets its regulations for this.
Yeah, that's correct. The jurisdiction to do NSL.
Okay, so what do they actually get with these subpoenas?
Information.
What information?
Mostly phone records, nothing content-based.
Nothing content-based. So it is simply metadata? Is that
That's
what you're-
correct, essentially.
Okay, all right. So the FBI is getting metadata with this.
That's correct.
All right. So under your harm 3 of no oversight, how do you claim to solve for the lack of oversight?
Well, because we're simply abolishing the national security letters. National security letters are the thing that the FBI is not being held accountable for. Therefore, abolishing the national security letters will clear up any confusion.
Okay, thank you.
Thank you. Are my judges ready? You were 3 minutes ago. All right, let's begin. Starting out on the topicality, we're going to start out by pointing out that this case goes outside the resolution. They uphold the resolution, but then they go outside the resolution by passing their plan. They violate the stock issue topicality. So let's start out with that. First, so we're going to break into 4 subpoints, so bear with me here. The first subpoint is of the interpretation, and that's of electronic surveillance. Electronic surveillance. Now, the resolution calls that the United States federal government should substantially reform its electronic surveillance law. So it clearly needs to be something that is actually dealing with electronics. That brings us to the B point, which is the violation. The violation. We actually see the violation in the background point. NSLs are not inherently electronic surveillance law. Let's take a look at what their definition is. It's a national security letter, is a law enforcement investigative tool, similar to a subpoena, and is most commonly used by the FBI. NSLs are used to obtain information from companies as part of a national security related investigation. What we see here is it's the same thing as a subpoena. Now, a subpoena, for instance, can be used for anything. It can be used for electronic information, and it can be used for physical records. The same thing goes for an NSL. An NSL is not inherently electronic. That brings us to the C point, which is the standard, common man. Common man. Any common man can agree that an NSL, a national security letter, could be used under this definition, under the same definition as a subpoena, to get something that's physical or something that's electronic. In other words, their case goes outside what the resolution asks for. That brings us to the D point, which is the impacts. The first of which is a rule violation. The affirmative team has gone outside of the resolution and therefore violated really one of the main rules that we have in STOA, which is that you have to affirm the resolution. They're not only affirming the resolution, they're going outside of that and affirming something else. That brings us to the second impact, is a loss of fiat. A loss of fiat. What we see here is that their plan, because it goes outside of the resolution, they no longer have jurisdiction to pass their plan. So now let's take a look at the criterion of the Constitution. They said that the Constitution is the criterion, the way you should weigh the round. You can take our response as net benefits. Net benefits. I would urge you to use the criterion of net benefits. Basically, weigh the advantages versus the disadvantages. Yes, the Constitution is important, but we need to be looking at other issues such as life. And so I'd urge you to keep that in mind into this debate round. Now let's take a look at the background points. Background point 1B, background point 1B was basically the numbers. They said there's 60 of these used a day. You can take our response as impossible to know. Impossible to know. Now, they argued later on that there's no oversight and there's no way to know how many of these NSLs are actually given out. If that's actually the case, then we have no idea whether 60 are used or not a day. So the impact is no significant use. No significant use. We do not see that NSLs are actually used significantly each day. Let's take a look at their background point 3, which is of gag orders. Now, they brought up a piece of evidence from the Electronic Frontier Foundation. You can take our response as has been reformed. Once again, has been reformed. The Electronic Privacy Information Center notes that the American Civil Liberties Union, the ACLU, has challenged the gag order provisions in 2 cases, Doe v. Ashford and Doe v. Gonzalez. In both cases, the judge ruled that gag orders were unconstitutional on both the 4th and 5th Amendment grounds. The Patriot Reauthorization Act of 2005 modified some of the gag order provisions. An NSL recipient may now disclose the fact that they have received an NSL in connection with seeking legal advice or complying with an NSL. NSL recipients are also given the ability to challenge in federal court compliance with NSL and gag order provisions. What we see here is that the gag order provisions have basically been cut off here. So there's a major reform here. The impact is not a real gag order. This is not really a gag order. It's not forcing the actual person to not correspond or say that I've been subpoenaed. In fact, they're allowed to not only contest in court, but they're also allowed to disclose the fact that they did receive an NSL when they're talking to a lawyer. So what we see here is that there has been reform. This is not the case anymore. My second response is the EFF. Once again, the EFF. The Electronic Frontier Foundation is basically a lobbyist group that is specializes in lobbying for electronic surveillance. Why is that an argument that's held today? The reason why we think we should hold that is because they're a lobbyist group. They're paid to say the gag orders are bad. That doesn't mean that they actually are bad, though. Now let's take a look at the harm 1, which is of a First Amendment violation. I have a couple responses here. My first response is NSLs protect First Amendment. Protect First Amendment. The American Bar Association in 2012 notes that the Patriot Act forbade the issuance of an NSL in any investigation predicated solely on the exercise of First Amendment activities. The impact is no impact. Once again, impact is no impact, ironically enough. Anytime an NSL violates the First Amendment, it's struck down. So what we see here is that this is not, in fact, an issue. Second response you can tag is Supreme Court has not ruled. Once again, Supreme Court has not ruled. This is really critical. The highest law of the land, the people who get to decide whether something is actually constitutional or is not constitutional, is the Supreme Court. The Supreme Court has not ruled NSLs unconstitutional. Therefore, we do not see this harm actually standing. Until then, it's just a reporter saying his opinions. I can come up and say that I think they are constitutional. That doesn't make me credible on the issue. What makes you credible is if you're one of the 9 justices on the Supreme Court panel. This is not a First Amendment violation. Let's take a look at harm 2, the separation of powers. A couple responses here. My first response you can tag as no suit provided. Once again, no suit provided. Now they cited a lawsuit that they said the impact was that it's a violation of separation of powers, but we never actually saw the lawsuit. So until we see that actual lawsuit, there's no way to determine whether that lawsuit's outcome was actually that. For all we know, they said maybe this is one of the outcomes, maybe not. We have no idea. Second response, though, is no appeal. No appeal. If it is true that this suit actually did have solid grounding, then it should have made its way up through the courts to the Supreme Court, and if it was a significant issue, the Supreme Court would have accepted it. But we didn't see that happen. That never happened in the status quo. What we see here is the impact is no violation. No violation. The Second Circuit Court never basically brought this violation up to the Supreme Court. Therefore, we see harm 2 is not actually a harm. Let's take a look at harm 3 of no oversight. I have 2 responses. My first response is that of the FBI ignores. Once again, FBI ignores. Now, what they were saying on harm 3 was that the FBI had ignored in several cases the restrictions placed on NSLs. What that means is that the issue is not the NSLs. The issue is basically misdirection and misuse of NSLs in the department of the FBI. That's really critical. What they cannot change the mindset of the FBI. If the FBI is set out on basically ignoring the current law, they will continue to do so. The affirmative team doesn't change that. It just switches their tools out. My second response you can tag is significance. Once again, significance. Basically, their plan is not significant because of the Hemisphere project. We'll break this into 3 subpoints. The A point is what NSLs see. What NSLs see. From the ACLU quoting the FBI, NSLs are administrative subpoenas that can be used to obtain several kinds of records: telephone subscriber information, long-distance billing records, and electronic communication transactional records. Now let's see what Hemisphere sees. This is a separate project. They say in the New York Times in 2013, the scale and longevity of the Hemisphere's project data storage appears to be unmatched by any other government program. The NSA stores data for nearly all calls in the United States, including phone calls, time duration for 5 years. Hemisphere covers nearly every call that passes through the AT&T switch. Unlike the NSA data, the Hemisphere data includes information on locations of callers. The impacts are twofold. The first of which is no solvency. Your records are still definitely going to be looked at in much greater detail than they are under NSLs. The first and the second is no significance. The affirmative team does not uphold the stock issue of significance because there's a much bigger issue in the status quo. That brings us to solvency 1. They were saying that there have been no basically attacks or no harms. I'd like to point out this is a solvency point of switch. They will switch to subpoenas. If the FBI is truly corrupt, they will merely switch their tools. Thank you very much. Oh, I now stand ready for cross-examination.
Great first speech. How are you doing?
I'm doing very well. How about you?
Doing well in finals. I'd like to first turn over your attention to topicality. And your interpretation was talking about electronic surveillance. And you said that national security letters are not inherently electronic surveillance, correct?
That's correct. In fact, your evidence actually describes it as something like a subpoena.
All right. Now, under your analysis, the very last piece of evidence you read, it describes the kind of information that NSLs subpoena, correct?
The evidence that I read was from your background point. So
under your solvency argument, or not your solvency argument, but addressing on number 3.
The last
addressed what type of information national security letters, the type of information.
The last piece of evidence that I read was actually from talking about the Hemisphere project,
right?
And that was talking about exclusively electronic information.
Okay, now you would agree with me that the only information that national security letters can subpoena is electronic information, correct?
That's actually not what your background point 2 said. It was very explicit. It said that it could subpoena business records. It could, business records can be physical.
Now, bank records and business records are electronic surveillance, correct?
Bank records can be physical. I have physical bank records at home.
Okay, thank you. Let's move to harm number 1 of First Amendment. Actually, before we go there, let's look to the background points. You said it was impossible to know the numbers. Is it possible to know how many NSLs are issued without the exact details of what the NSLs entail?
If you want to present evidence to that effect, we're more than welcome to look at that.
Didn't we present that evidence in harm number 3?
Can you point that out to me? Sorry, well, I don't know what the case is, but yeah, I would contend that we can't know.
Yeah, why can't we know?
I would contend that we can't know because, as you said, there's no oversight. So if it's really true that the FBI is fudging when they can use it, they can definitely fudge how many NSLs are actually available.
All right, let's turn our attention back to point number 3. You said that it has been reformed, and you read a quotation from the Patriot Reauthorization Act of 2005 discussing how the NSLs were amended, correct?
That's correct.
Now, who pressed for this issue? Who were the ones advocating in your
I believe it was the ACLU. They were the ones that filed a lawsuit in favor of basically opening up the NSL gag order restriction.
Now, why do we have evidence from 2013 and 2014 describing the implications of our First Amendment gag order rights and how they're still being violated in the status quo?
I would contend that they're not being violated in the status quo right now, that your evidence actually misrepresents how the gag orders are used. Essentially, these aren't really gag orders anymore. The people are not gagged. They can give their information both to a legal counsel and to a court.
Why do we have court cases discussing how gag orders are actually implemented in the status quo?
That's actually
post-2005?
a great question. We don't have any court cases. We have yet to see any court cases.
You referenced the Second Circuit.
You referenced it, but we need to see the actual ruling in order to determine that's what it said.
Okay, now that wasn't an argument you made in your speech. Why do we need to see the actual ruling?
It actually was an argument that I made. We need to see the actual ruling so we can verify that the reporter was representing the material correctly.
Okay, and can I just lastly see a couple of pieces of evidence?
Yeah.
Can I see the evidence under harm number 1, background point number 3, and under solvency, under your second significance, your second response in harm number 3 of significance?
Sure. Go ahead and take it all. We'll split safe.
All right. Thank you.
Thank you.
Judges ready? And timer? And my opponents? All right. Of all the dangerous government surveillance powers that were expanded by the USA Patriot Act, the national security letter power under Title 18 of the US Code, as expanded by Patriot Section 505, is one of the most frightening and invasive. These letters served on communication service providers like phone companies and ISPs allow the FBI to secretly demand data about ordinary American citizens' private communications and internet activity without any meaningful oversight or prior judicial review. It is because we stand with the Electronic Frontier Foundation that I would strongly encourage you to vote for the affirmative at the end of today's round. We're going to be getting to firstly understanding the issue of topicality. However, when taking a look at his argument talking about electronic surveillance. Now, Jack's point here is basically saying that national security letters aren't inherently electronic surveillance. I have 4 responses. Before I get there, I'd just like to point out that he kind of misconstrues our background points here. He basically takes our background and then tries to assert that, well, it could be more than just electronic communications. That's false. My first response is electronic surveillance. Electronic surveillance. Not only is national security itself an electronic surveillance tool, It's also authorized under electronic surveillance law, and the information collected is all electronic. As we can clearly see, this only deals with electronic surveillance. I'll be having, my next 3 points, I'm going to be demonstrating that, and specifically looking to my second response, which is policy reform. My second response is policy reform. Again, reference back to the background point from the Electronic Frontier Foundation, which said that NSLs are currently authorized by the Electronic Communications Privacy Act. This is the big one that we're talking about. The Electronic Communications Privacy Act basically is the way that the government uses in talking about one of the largest electronic surveillance laws. By reforming this particular law, we are absolutely upholding the resolution. My third response, authorized under electronic law. Authorized under electronic law. Let's take a look specifically at what an NSL actually is. We take a look at what the Department of Justice said in 2011, quote, under ECPA, the FBI may obtain subscriber information, toll billing records, and electronic communication transactional records from a wire or electronic communication service provider, such as a telephone company or an internet service provider. This is the NSL authority that is used most frequently by the FBI. My fourth and final response is info collected. Info collected. And here I'm going to be talking about how he misconstrues our background point, and again, reaffirming what the Department of Justice says. Examples are account numbers, physical addresses, subscriber telephone numbers, IP addresses, and other non-content information. Furthermore, the Electronic Frontier Foundation says in October of 2014 that the most commonly issued NSLs permit the FBI to target telephone and internet companies, financial institutions, and credit agencies to obtain customer records relevant to an authorized investigation to protect against international terrorism or clandestine intelligence activities. Note my opponents bring you no pieces of evidence saying that NSLs are actually doing anything outside of electronics. They're also authorized under the Electronic Communications Privacy Act. Clearly, they're electronic by the policy we're reforming, what an NSL actually is, and the information that is collected. Let's take a look at the response to the background. Actually, before we get there, let's take a look at the criterion. They talked about how it needs to be human life. I'm going to be using the analogy of a car. Now, what my opponents are asking you to do is to look at a car. When you're buying a car, they want you to look at every aspect of the car, which might seem like a good idea. You want to look at the engine, you want to take a look at the transmission, the color, the type, all of these different things. We as the affirmative are asking you to do one simple thing. Does the car drive? Is the government actually operating under constitutionality? We don't believe so, which is why the criterion is the Constitution. Let's take a look at the background points now, talking about specifically under subpoint B of the numbers. He argues that this is impossible to know. A couple of responses here. My first response is FBI self-reported. FBI self-reported. Now, the numbers we're using are the numbers that the FBI actually gave us. But furthermore than that, my second response is numbers deflated. Numbers deflated. The numbers that the FBI gave us were actually substantially less than when Congress actually looked to oversight, which is what we turn to when looking to harm number 3. Clearly, what we can see here is the fact that we do absolutely have this particular number. These are not in contradiction with each other whatsoever. Let's turn to back on point number 3 and discussing gag orders. I have a couple of responses to this. My first response is ruled unconstitutional. Ruled unconstitutional. Now, Jack brings up an interesting point here. He argues a couple of court cases which actually confirm that national security letters are unconstitutional. I think this is actually a great point for the affirmative team's side. The specific court case that he brings up basically argues that national security letters are quite literally unconstitutional. This is the basis of the affirmative team's case. We turn this argument. But secondly, when taking a look at his impact, he talks about how there's no gag order, essentially. My second response here is companies can't disclose. Companies can't disclose. Ellen Nakashima, writing for the Washington Post in November of 2014, says a Justice Department attorney last month asserted that companies that receive national security letters can comment on the quality of NSLs they receive. The suggestion that a recipient can publicly discuss the fact that it has received one or more NSLs could discuss the quality of the specific NSLs received is absolutely mistaken, unquote. As we can clearly see, the companies really can't disclose this type of information. The gag order is actually hurting when discussing the idea of a First Amendment violation, which we'll turn to now in discussing the idea of the First Amendment violation. So he has 2 responses to our first one. His first response is saying that, well, the NSLs protect the First Amendment. I find this interesting because the courts have ruled against this. When we look to his second response talking about Supreme Court hasn't ruled, I have a couple of responses. My first response is court rulings. Court rulings. Now, he actually makes the argument that we haven't brought up a single court case. Look to the Electronic Frontier Foundation in harm number 1 of our evidence, where it talks about the Second Court of Appeals and the District Court for the Northern District of California have both ruled that NSL gag orders amount to unconstitutionality, essentially. My second response is no appeal. No appeal. Now, this is a very important point. He's essentially saying that we need a Supreme Court case. However, this is incorrect. If the judges have decided The only way it can get to the Supreme Court is if the defendant reappeals the case, which we don't believe they have. Let's take a look at harm number 2 in discussing separation of powers. And before I get there, I'd just like to clear up who the Electronic Frontier Foundation is. He argues that they're essentially a lobbyist group. This is actually incorrect. They're essentially they're very much like the ACLU in it of the fact that they're essentially a civil liberties organization. They don't actually lobby. Let's take a look at the harm number 2, however, in discussing separation of powers. He says that we provided no lawsuit. My response here is judge's decision. Judge's decision. David Pereira said in March of 2013, violation of separation of powers comes from the statute's circumscription of judicial review of the non-disclosure. Ilston says, since it places the essential insurmountable standard, no reason to believe that a harm may result before recipient appealing a non-disclosure order. The unconstitutional non-disclosure provision isn't severable from the issue of NSLs, the judge adds, unquote. As we can clearly see, this is a judge's decision. You can also cross-apply my argument talking about the appeal to a second response. So let's move on to harm number 3. This first point was talking about how the FBI ignores, and you can also cross-apply this argument to switching to subpoenas. My response here is no authorization. No authorization. Now, again, they didn't read a piece of evidence under this, but also understand the fact that the FBI can't actually authorize an administrative subpoena anymore because we take away that power by reforming the 4 statutes that actually authorize them to grant an administrative subpoena in the first place. With that, let's finally touch on the last argument on the flow, which discusses significance. And he argues that your information is still going to be collected. 2 responses. My first response is collection of information, not a problem. Collection of information, not a problem. Note we never talk about how your privacy is being violated or the 4th Amendment is violated. We believe that your rights are violated in different ways. But my second and much more important response is most significant issue. Most significant issue. Recall back from the introduction that I gave, talking about how this is one of the most significant problems that our electronic surveillance law has today. Thank you very much. And I now stand open for cross-examination.
All right, so just a couple questions today. First, I know you don't have the court decisions, but can we see a summary of those court decisions?
I can take a look back at the table to see if I can get that to you.
Okay, if we could get those as soon as possible, that'd be great. While we're talking about
I think those are kind of unnecessary, but I can take a look back at the table.
okay, but if they are there, we would greatly appreciate if we could see those as soon as possible.
Sure.
Now, while we're talking about evidence, can I see all the evidence that you read? And then I'm going to have you point out a couple pieces here.
Sure.
So, which card said that the companies could not disclose?
That was under this piece of evidence here. Would you like to see that? It's right here.
Yeah. Okay. So, all right. So this card says companies can't disclose.
Yes.
All right. And then which card was the judge's decision?
The judge's decision, that was this piece of evidence here.
All right. Okay. Is this the entire judge's decision?
That was a quotation from the judge's decision. We actually quote the judge specifically.
Okay. Do you have the rest of the decision?
No.
Okay.
I'm not sure if this is necessarily a decision, but an opinion on the national security.
Okay, so this is the judge's opinion upon the decision.
That's correct.
I see. Okay, so this isn't actually a court ruling. This is just a judge's opinion.
We don't necessarily have to have a court decision to prove something is unconstitutional.
I see. Alrighty. So your contention though is that that's his warrant. That's your warrant. Is the judge said that it's unconstitutional?
Our warrant is specifically outlined in our harm. We're just giving you some more evidence and advocacy to the facts.
So you're saying that thousands of people have been illegally NSL'd or have national securities letters put on them, and you're saying that only 2 cases have been appealed to courts? Are there any other examples?
Our argument is not necessarily that the collection of the information is illegal, but rather when the gag order is placed on them, and it's a First Amendment.
Okay, so how many times were gag orders given out?
They're given 97% along with.
Okay, so we're still talking about thousands of gag orders then.
Sure.
So why have no other gag orders been appealed to any other court?
Most of the time, it's not necessarily on individuals, but corporations specifically.
Okay, and you're telling me that corporations just roll over and say it's okay, you can.
Again, if you take a look at the evidence, they can't actually disclose the use of national security.
Okay, so it's your contention that the company cannot disclose?
Yes, that was actually.
And that they're not even allowed to take legal recourse?
The few that have when we take a look at the 2 Supreme,
right,
the two cases that we mentioned.
Yeah, you can see where I'm going with this. So how did those 2 court cases
I don't
happen?
believe that this is a necessary issue to talk about. If you want to prove that two
that's what I'm
court
asking.
cases is insignificant.
How did the 2 court cases happen if they can't disclose.
Oh, they can't disclose that that they've been having a gag order.
So they do have legal recourse, though.
They do have legal recourse, yes.
I see. Okay, so that is not an actual gag order.
It is a gag order.
Okay, all right. So let's keep talking. So where in the ECPA does it actually allow NSLs?
If you take a look at the specific piece of evidence that I brought up, it was section 18 of the U.S. Title Code, subsection 2.
And if I could see that piece of evidence, that'd be great. So do you remove that section?
We reformed the specific part of the ECPA, so yes.
What's your reform of section 2? Sorry, what's that section?
Okay, I can answer the question. That's
Okay.
that was good.
Thank you very much.
How loud is this?
Okay.
Ready? Everybody ready?
In this second negative constructive, what we're going to be looking at is first off the significance point, then multiple significance points, and then looking to solvency, and then looking at the disadvantages, how the alternatives to the current system have much more violations of both privacy and the freedom of speech. Well, let's first look at the significance points. Significant point 1 is that of no determination. No determination. Now, what we see here is specifically the courts have not come to a conclusion. We can actually see this from one example of that of their court case. Now, many of their court cases, they haven't ultimately shown exactly the court case itself and the decision the judge read himself, but they did give us one specifically. If you actually look to the one they gave, it was out of the Northern District of California. And the Northern District of California did rule this to be unconstitutional, but what's important to realize is that he actually left it up to appeal. The Northern District of California didn't come to a conclusion. Rather, he says it has implications of a violation of unconstitutional. He then passed it along to the Ninth Circuit. Now, the Ninth Circuit has not decided, and that's the impact here, that of no conclusive decision. This is an example of how the affirmative team has suggested things that ultimately haven't come to a conclusion yet. They said, oh, well, they won't appeal the decision under the Second Circuit. Yet they've read no evidence for this. They've read no evidence since the Second Circuit saying that there was no appeal process. We can see the one example, the district court, they did not mention the fact that it actually did become appealed. Now, they haven't read the actual decision, but we can see actually from their evidence, this decision itself was appealed. According to the Daily Cost, in 2014, they said, in what has been characterized as a sharp rebuke to the federal government, Judge Ilsen ordered that the FBI to stop sending NSLs altogether, but put the ruling on hold in order for the government to file an appeal. That appeal is happening now. Now, the affirmative team has not showed the result of this. What's really clear here is that of the lack of conclusion. What we see in this round is there's an appeal going on, yet no conclusion has been made. Let's look at the second significance point. The second significance point is that of legal recourse. Legal recourse. Now, the A point is that of built into NSL. Built into NSL. If we actually look to the NSL program, there is legal recourse built into the policy. According to the American Bar Association, in 2012, they stated, NSLs are a type of administrative subpoena that can be invoked only in terrorism and espionage investigations. They can be issued by the FBI to limited types of third-party record custodians. The custodians can object if compliance would be burdensome, and the FBI cannot simply take materials from the custodian. So that's really important to realize here is that the issue with the NSLs actually have objections. The actual people who receive the NSLs, first off, are not even the people who have the information in the first place. They're not the people who originally created the information, the third parties. But second, it's no violation of their First Amendment rights because they do have the ability to object. This leads us to that of the B point, that of proven cases. The idea that they went to district courts and the idea that they even went to appellate courts shows the fact that these court cases can be created, and there is actually legal recourse. There would be no possibility for there to be court cases if there were not legal recourse. Now, the reason for this is the fact that to be a defendant in a court case, you have to have an actual tangible impact in that court case. So what's important here is the fact that the impact, that of legal recourse stands. Legal recourse stands. Now, yes, you can't go post this on Facebook, but what you can do is go to the court and actually have your opinion be heard. Let's now look down to significance point 3, that of no separation in the Constitution. No separation in the Constitution. Now, if we look to actually one of the harms, and basically the entire point of the affirmative team is that it's a violation of the Constitution. I'd like to quickly point out that there's nowhere in the Constitution that actually suggests the idea of separation of powers. Actually, judicial review of the Supreme Court and the courts was actually created through a court decision. The idea of actually interpreting the Constitution was through the court's interpretation themselves. So this idea of judicial review, it's not part of an amendment to the Constitution. It never shown the clear violation in the Constitution. Let's now move down to solvency point. The solvency point is that of corruption. Corruption is not solvable. Corruption is not solvable. We can actually see an area where a district court ruled specifically on a different type of search that was banned in that area, yet the FBI continued to use that type of search. According to constitutional law expert Matt Gearway, writing for AllGov, May of 2013, he says, despite a federal appeals court ruling, the government snooping on emails required a search warrant, the FBI and other federal law enforcement regularly ignore this constitutional mandate, according to the documents obtained by the American Civil Liberties Union. What we can see here is when there's actually an injunction, somewhere that they're actually being stopped from doing something, the FBI ignores this and just finds some other justification for what they're doing. The affirmative team has claimed that they're abusing this power, and that's exactly what will happen after an affirmative team's ballot. There is no solution in more regulations. There is no solution to corruption in more regulations. Let's now look down to the disadvantages. The disadvantage one is that of a switch to 215, a switch to 215. Now let's first look at the background point, the A point, background point. And one, NSL is widespread. The NSLs are widespread. Now the affirmative team backed this up in their 1AC, but according to technology specialist attorney Eric Sinrod, March of 2013, he says, the FBI has issued an average of nearly 50,000 NSLs per year. The second point is that requirements exist. Requirements exist. American Bar Association, 2012. NSLs are a type of administrative subpoena that can be invoked only in terrorism and espionage investigations. As I pointed out earlier, there is actually recourse for this specific instance. Now let's look down to the B point, that of ASP removes NSLs. The affirmative team removes NSLs. This leads to the C point, that of the internal links. The first internal link is that of agent switch to 215. Agent switch to 215. According to the Cato Institute researcher Julian Sanchez, January of 2014, they said without NSLs, agents would almost certainly favor 215 orders and conventional grand jury subpoenas. What we see important here is, yes, there are two different types here, but the 215 is really what we're going to focus on. And let's leave this to internal link 2. 215 is abusive. 215 is abusive. According to the American Civil Liberties Union, they said Section 215 vastly expands the FBI's power to spy on ordinary people living in the United States, including United States citizens and permanent residents. The FBI need not show probable cause nor even reasonable grounds to believe that the person whose records is seeked is engaged in criminal activity. The FBI does not have to have any suspicion that the subject of the investigation is a foreign power or an agent of foreign power. The ACLU in 2006 point out that Section 215 gags recipients automatically and authorizes broad demands for information. This leads to the D point, that of the impact. The impact is that of a case turn. We ultimately see them shift to 215 that is automatically abusive. It automatically uses gag orders. Now, the affirmative team probably will get up here and say, oh, well, 215 is set to expire. Now, my response to this is more political power. More political power. Currently, only the NSA is really supporting the continuation of Section 215. Ballot, you now have the Justice Department and the FBI supporting the continuation of Section 215. So this has a political implications in the United States government. So we'd actually see a continuation of 215 as the Senate's recent votes show a very close margin. So we would push them over the brink to actually extending this 215 possibility and the FBI switching to this program that ultimately automatically gags and automatically searches your information. Thank you.
Hi, Johnny. How are you doing today?
I'm doing good. How about you?
I'm doing pretty well. Let's take a look now down at your response that you made. Firstly, take a look at your significance points and your solvency and disadvantage. Before we get there, so you would agree with me that the courts have ruled this to be unconstitutional, correct?
Certain courts have, but certain courts have also ruled many different things unconstitutional, and then they've been appealed.
Have we ever seen from the negative team a court ruling saying that national security letters are constitutional?
No.
Okay, so we don't have any evidence from the negative.
I'm assuming the fact that you didn't quote the Ninth Circuit probably means they didn't agree with you because they have made a decision on this in 2014.
We do actually quote the Ninth Circuit under the first.
Oh, sorry, I'm not sure if I meant the Ninth Circuit. I meant the one who appealed from the Northern California.
And that went to the Ninth Circuit, correct?
I'm not actually sure.
Okay. Can I see your evidence? Can I see your evidence of that? Thank you.
I believe your actual evidence was the district court and then the appeal.
Thank you. Let's move down to your significance point number 2, talking about legal recourse. So you're saying that having a gag order is okay because companies have legal recourse?
Yes.
Okay, so you're saying that that it's okay for the FBI to essentially say that you can't share any of this information, limiting your First Amendment rights because they have a legal way to get out of it?
Yeah, First Amendment rights aren't universal. The freedom of speech doesn't allow me to start yelling bomb in the airport, basically.
Fair enough. Okay, I see what you're saying. So have we seen any reason to keep national security letters?
Well, they would switch over to basically more dangerous programs.
Okay, and do we see any evidence specifically in that in your speech?
Yeah, I actually had an evidence card from Cato Institute saying they would switch over.
Okay, but Section 215, like you talked about, is set to expire, correct?
That is true, but just to be clear, Congress is currently reforming the section that allows NSA bulk data. They would still continue with 215 for the
Okay, now the entirety of the Patriot Act is set to expire soon, correct?
They have reauthorized it many times over.
Okay, let's take a look at your third significance point. You talked about how the separation of powers isn't constitutional. Then why have the courts ruled that it is?
No, it's something that's set up in our statutory laws and through court precedent. But what's important to realize is court precedent isn't necessarily the Constitution. It was actually set up in Marshall, I forget, Marshall versus,
Okay.
I don't know, you probably know, but it was set up in an actual court decision.
Okay, I see what you're saying. Let's move down to solvency point number 1. You talked about corruption is unsolvable. And you brought up a specific example.
Yeah.
Can I please see that?
Yes.
Now within this specific example, the FBI was able to use this tool because they were able to get it authorized under a different statute. Yes.
I'm not specifically sure. I do know they found a way around it because of the corruption that still stays in the system.
Thank you. No further questions.
No prep needed. Thank you, Dustin. Alrighty, are we all ready? Then let us begin. So I'm going to respond to the arguments against my original speech, starting out with the topicality point, basically saying they're going outside of the resolution. They had 4 responses. You can actually group all of those. The evidence that they gave me very much so clears up the issue of topicality. We see that part of their plan is topical, but 3 other parts are not. So let's take a look at their actual, I'm going to read the definition and tell you what my response is. This is the piece of evidence that they gave me. NSLs are currently authorized by 4 federal statutes: the Electronic Communications Privacy Act, the National Security Act, the Right to Financial Privacy Act, and the Fair Credit Reporting Act. What we see here is that one of those has to do with electronic communications. The other 3 do not. The impact, or the argument tag, I guess, or the title of the argument is 4 laws. 4 laws. Now we see that there are 4 laws. We see the ECPA, the Electronic Communications and Privacy Act, that is topical. But what are the 3 other laws that they're changing? They're changing the National Security Act, which inherently doesn't have anything to do with electronic surveillance. They changed the Right to Financial Privacy Act, which again has nothing to do with electronic surveillance. And finally, the Fair Credit Act, which blatantly has nothing to do with electronic surveillance. What we see here is they have gone outside of the resolution. They're blatantly changing code that is not electronic surveillance law. It's credit law. We're dealing with other issues. What we see here is that they are extra topical. Therefore, the impact still stands. They do lose their fiat power. They're violating our interpretation still. Let's take a look at the net benefits argument now. I said that net benefits is reasonable and you should prefer it because the Constitution is too narrow. We should look at something too broader. They said, look at a car, you want it to be running. The exact response is if it's weighable, it's votable. Once again, if it's weighable, it's votable. The reason why you should prefer the net benefits criterion over the Constitution is because we need to be weighing the issues. You need to actually be able to quantify and weigh an issue when you're debating it. And what we see here is that the Constitution, yes, it does have weight, but we need to be able to look at other issues outside of the Constitution. It's unreasonable to limit everything in the Constitution. If that were the case, there would be some major issues in the world today if we only based all of our decisions on the Constitution. Now let's take a look at the background point B of numbers. They said it's impossible to know. They said the FBI self-reported and that the numbers were deflated. You can tag our response to circular reasoning fallacy. Once again, circular reasoning fallacy. They're saying the FBI reports are deflated because of self-reporting. And then they say because of self-reporting, the FBI reports are deflated. This is circular reasoning. We're not actually getting a real answer here. Their whole argument is that there's no oversight. If that's the case, then they're not significant. They cannot prove to you that there are actually 60 letters a day. There's no way of verifying that. Let's take a look at the next background point, which is with gag orders. My response was basically there's been a reform. They said that it's been ruled unconstitutional and companies can't disclose. You can group both of those arguments. I have two responses. My first response you can tag as no ruling presented. We have yet to actually see a court ruling, the actual text of the ruling, or a summary of the ruling. We'll talk about the one that they gave us later. It wasn't actually a summary. Really, it's really important. We can't actually see whether it's constitutional or not based on just reporters' information. Second response, though, is decisions prove. Once again, decisions prove. What we do see is if you believe their actual rulings, if you believe the fact that these have been appealed to courts in some way or another, the companies have used legal recourse, that proves the fact that the companies can, in fact, disclose their information. This is critical. We got this out of them in cross-examination. The impact you can tag is not gag orders. Not gag orders. This is not a gag order. The company can go and take legal recourse if they want to, and that is not a gag order. They're allowed to bring it up in court. Now, on the gag order, I was saying it's not a gag order. They say companies can't disclose. Cross-file my arguments there. It's the same thing. There's no way these court cases could ever happen if gag orders didn't exist. If a gag order was actually in effect. Let's move on down to the next argument, which is of basically the First Amendment violation, and then the Supreme Court didn't rule. I want to talk about that. So they had two responses on the Supreme Court didn't rule. First, they said there were two court rulings, and then there was an appeal as thousands of opportunities. Once again, thousands of opportunities. They say that NSLs and gag orders are used thousands of times. They said 60 times a day. That's a significant number. And what we see here is that only two of those have ever been appealed in the entire history of the United States. What we see here is the impact is not unconstitutional. We do not see an unconstitutional value here. The reason why is because simply put, the precedent of court rulings is not in their favor. On the judge's decision that they gave us, I have two responses. They were saying that we have a judge's decision. First of which is that this is a reporter's opinion on a judge's opinion. A reporter's opinion on a judge's opinion. This is a judge's opinion that a reporter was reporting on. Nowhere in the evidence is the word gag order even mentioned. For that reason, this does not apply. This does not qualify as an actual court ruling. Moving on down to the argument that the FBI is ignoring and they don't solve. They said they authorize. You can take response is not authorized currently. They're doing things that are illegal now. There's no reason to say why they won't do them after their plan. Thank you.
Yeah, can I see the reporters? Yeah.
All right, are all of the judges ready? Okay. I'd like to first start off with the second negative constructive, addressing the significant solvency points in the dissent that he brought up, and then addressing the first negative rebuttalist arguments. Keep in mind that a lot of the arguments that the second negative constructive presented also cross-apply over to what the first negative rebuttalist said. I'd first like to start off with significance point number one, talking about no determination, how we didn't actually come to a conclusion on the court. His first response, we have no evidence. He said that the court ruling was appealed. He had no evidence for this. But my second response is much more important. That is a conclusive decision. conclusive decision. Let me read you the quotation from the Northern District of California. It says, this is from the Electronic Frontier Foundation in 2014. It says, and in 2013, the EFF won a landmark decision in the Northern District of California in which Judge Susan Ilston declared one of the statutes unconstitutional in its entirety. Unfortunately, the Obama administration has instead continued to block reform and has even sought to expand NSL powers. Here we can clearly see that they did actually come to a conclusion on this. Judge Ilston did rule that national security letters were unconstitutional. But my third response is no appeal. No appeal. Essentially, when he talks about how they offered it for appeal up to the federal government, it's essentially like when people are getting married and they say, speak now or forever hold your peace. The government is just essentially holding its peace. Let's look to significance point number 2, talking about legal recourse being built into national security letters. He said that we have proven cases and there's legal recourse. 2 responses here. My first response is legislative process is necessary. Legislative process is necessary. This is a key argument because what the quotation I just read talked about is that the Obama administration definitely needs, or the Congress needs to, some type of legislation needs to be taken on national security letters. But my second and much more important response is basically the issue talking about the legal recourse. You can tag this response, excuse me, as gag orders. Gag orders. Essentially what this means is that people don't actually know that they have legal recourse because of the gag order, and basically because there's no accountability within the FBI. People don't actually know that they actually have access to this type of legal recourse. Let's move to significance point number 3, talking about no separation in the Constitution. You can tag my response as district court. District court. A district court has specifically ruled, Judge Susan Ilston in the Northern District of California specifically ruled that national security letters violate the First Amendment and the separation of powers in Article 1, Section 8 of the Constitution. Solvency point number 1 was talking about how the corruption is insoluble, and Judge Jack alluded to this in his first negative rebuttal as well. My response is no justification. No justification. They make the argument that the FBI will simply just do the exact same thing that they've been doing post-plan. However, there's no justification for the FBI to engage in such activity. What my opponents are talking about is that the FBI will simply switch their position. However, it's important to note the fact that there's absolutely no justification for the FBI to do so. Now, their empirics are talking about when the FBI switched its justification to something else, but essentially, when we abolish national security letters, there's nothing for the FBI to justify themselves through. Let's use the disadvantage talking about switching to 215. This is section is 215 has ended. 215 has ended. Let's look to a quotation from the Justice Department, March 12, 2015. They say if the government seeks to renew the authorities approved herein prior to their expiration on June 1st, 2015, the government is directed to file the proposed renewal application no later than Friday, May 22nd of 2015. Essentially, if the government wanted to renew the Patriot Act, they would have had to do so by yesterday. They didn't. Let's look to a quotation from Rand Paul, who reported at 5:54 a.m. this very morning, quote, "This week I stood on the floor for roughly 11 hours in defense of the Fourth Amendment and successfully blocked the renewal of the Patriot Act." Note the word blocked is past tense, not blocking in present tense, but blocked. He has blocked the renewal of the Patriot Act, which means they won't be switching to 215 because Section 215 is basically expired. Let's turn over to the first negative rebuttal argument, starting off with topicality. Now, he talked about how our own piece of evidence indicted us on T. My response is electronic surveillance data collected. Electronic surveillance data collected. Under all of these 4 statutes, the only data collected by national security letters is electronic surveillance. Let's turn over to the background points now. Background point number 1, subpoint B. He said that it was impossible to know, and that was circular reasoning. You can tag my response as different numbers. Different numbers. When we articulate the FBI is misconstruing the numbers, what we're talking about is completely different numbers and how many NSLs they issue per day. Back on point number 3 was talking about gag orders, and again, he talked about how the no ruling presented and the decisions prove that they have the authorization to basically exempt themselves from gag orders. You can tag my one response as people won't actually do it because they don't know of the provisions of legal recourse. That's important because the gag order doesn't give them the opportunity, doesn't alert them that they have legal recourse in the status quo. For all these reasons, because of the constitutional violation, that I strongly urge you to vote for the affirmative. Thank you very much.
Is everybody ready? So through this final negative rebuttal, what we're going to do is just boil down the round into the voting issues. Let's first start on voting issue number 1, that of the status quo solved. Don't worry, I'm not running a new argument. This is just basically significance, saying that the current situation doesn't show any harm that the current situation is not fixing. We're going to see this in 2 basic ways. The first point that we can see under here is that of no determination. No determination. Now, under this point, they said that of no evidence. There's no evidence of appeal. But actually, I did read evidence under this point from the Daily Post. I'm not sure if I'm pronouncing that right, but it was from the Daily Post actually saying that there was an appeal and there was not an actual injunction. He never actually stopped the practice. He said, I may stop the practice, but here's the appeal. The evidence was read in my speech, and they claimed that the evidence wasn't read. So the evidence absolutely was read in here, and there was appeal without an actual stop. An appeal without an actual stop. Now, this judge ruled his opinion, or her opinion, sorry, her opinion was that it was unconstitutional. What was important to realize is she wasn't sure enough to actually stop the practice. Instead, she appealed it, she allowed it to be appealed to the Ninth Circuit. Now, under their second point is that of no appeal. They said that there isn't any appeal, but I read the evidence card first off, but second off, this is the point. They continue to bring up the court decisions without showing any context or any future decisions after them, showing whether or not they have been appealed. They haven't really shown you the full facts. Rather, they've just shown you the beginning and not shown you the end. They haven't shown you the full story of these actual court cases. Now, an example is a little bit funny, but New York State Court, it's not a federal court, but a state court, ruled that primates also have the same rights as humans. Now, this, of course, was later appealed. But the idea is just because you can start a discussion doesn't mean the conclusion stays the same. Our courts constantly overturn court cases. That's why we have a circuit court called the Court of, that's why we have multiple circuit courts called the Court of Appeals, because things are constantly being appealed and the court cases do not stay the same. Ultimately, it's the affirmative team's burden to show you that it stayed the same, that it actually stayed unconstitutional, but rather they do not actually show you that. Therefore, there is no determination. But let's look to the second point, that of recourse. Now, under this point, we can see that there's really no harm under the current system. Now, the response here is that people don't know about the recourse. I'd like to point out, it is not the government's job to tell people their rights. Rather, it is the government's job to let people have rights. It is their fault if they do not know their rights. That's not the government's job. Rather, they actually accepted the fact that legal recourse exists, which the impact still stands, not a violation of your First Amendment. Just because you have a violation of the First Amendment doesn't mean the government has to broadcast it to you and tell you you have that right. What's important to realize is it's the people's job to actually understand what their rights are under these laws, and their rights are secured. The second impact here is that of proof of change. Into my significance point 1. As my partner actually read, don't worry, this isn't new evidence, but my partner read an evidence card talking about how in 2005, court decisions changed the way we reauthorize the Patriot Act. According to electronic privacy information, the American Civil Liberties Union has challenged the gag order provision in 2 cases, Doe versus and Doe versus Gonzalez. In both cases, the judges ruled that the gag orders were unconstitutional on both Fourth and First Amendment grounds. The Patriot Reauthorization Act of 2005 modified some of the gag order provisions. What we see is the current situation does have recourse, and that recourse ensures First Amendment protections. If there is actually a problem, the decision will be reached by our courts. They urge you to stick with the idea of a separation of powers. But honestly, the separation of powers should leave it in the judge's hands. They're actually going against their philosophy in the first place. To truly stick with the separation of powers, it would be to stick with the legal recourse they have as of now. Let's now move down to the voting issue number 2, that of extra topicality. Now, the extra topicality point, the violation here still stands under the 3 different laws. Now, their argument is that of the ECPA is electronic communications privacy. But the affirmative team can't just go, oh, here's part of the resolution and here's the rest of the resolution. They must completely fit within the resolution. And if you look at their mandate on itself, prima facie, in a vacuum, is absolutely not fully topical. It goes outside the resolutions 3/4 of it goes outside the resolution. Sure, some credit reporting can be electronic, but it is not inherently electronic, and that's really where the violation comes in. Their plan is not inherently electronic surveillance law, therefore it violates the topicality. Thank you.
Yeah.
All right, judges ready? Okay, time. In what will be my last ever speech and debate speech, I'm going to be covering my opponent's voting issues, really showing you why, in fact, an affirmative ballot is still warranted at the end of today's round. The first voting issue for the affirmative team, however, I'd like you to write down as speculation is not a reason to vote negative. Speculation is not a reason to vote negative. Now, what my opponents have essentially done, and spent 4 minutes of their 2NR in their speech, is essentially a bunch of speculation points. That the affirmative has to do this, and the affirmative has to do this. And I don't believe that's a fair burden for the affirmative to prove, as we'll be seeing in my responses to their voting issues. Let's take a look at their first point. They talked about how there's no determination. Now, understand, judges, that they never really answered what I talked about in cross-examination. Now, we don't have to have a Supreme Court case or necessarily even a court case to prove a constitutionality violation. We can actually look to the warrants for this in the evidence. But furthermore, we actually do prove that there is a constitutional violation in discussing the 2 court cases that we brought up. Now, Johnny and Jack bring up a 3rd court case and say, well, they haven't decided on this. It's essentially gone to the Court of Appeals. But note the fact that they don't bring up any evidence of what the government has actually ruled on. All we have is the original judge who decided that this was unconstitutional under the First and Fourth Amendments. Clearly, we can see that all of the advocacy in this round is on the side of the negative, or on the affirmative. The negative team has not read a single piece of evidence saying that national security letters or the gag orders are unconstitutional in any way, shape, or form. They're essentially saying that, well, it could go to the Court of Appeals, and we need to show that this has gone to the Court of Appeals and the court has ruled this way. Unfortunately, those other two court cases, we don't believe have actually gone to the Court of Appeals. So why would we have evidence saying it has? It just doesn't make any logical sense. Let's take a look now down to subpoint B, talking about the idea of recourse. Now, under this point, we can actually take a look at my partner's arguments on talking about how they don't know, and second of all, how the companies can't disclose placed on them. Now, note the fact that they dropped the latter part of that argument. Let's take a look at a specific firstly point, talking about the idea that they have to know their rights. Now, what essentially Johnny's point here is the fact that, well, they have to have the right to legal recourse even though they don't know about it, which makes it somehow constitutional. This is incorrect on its face. The gag order in and of itself, because it tells companies that you can't disclose the information, just because they don't know that they have legal recourse doesn't make it okay. It doesn't make it constitutional. And in fact, if we take a look at their evidence that they read under their second impact, the courts have ruled that under the First Amendment, national security letters and gag orders are unconstitutional. Let's take a look at their impact cards now. Now, specifically taking a look at their second impact, talking about proof of change. Now, under this point, they say, well, the Patriot Act reformed national security letters. My response is the Patriot Act expanded national security letters. If we take a look at the piece of evidence that I actually read in my first speech, we take a look at the introduction that I read of all the dangerous government surveillance powers that were expanded by the USA Patriot Act. The national security letter power, as expanded by Patriot Act Section 505, is one of the most frightening and invasive. So when they tell you that that NSLs have been reformed, yeah, they have. They've only been expanded by the Patriot Act. This only goes to further the affirmative team's point. Let's take a look at the second voting issue in discussing the idea of extra topicality. And they continue to pound the idea that we're not topical, and that's going to be my second voting issue, stock issues upheld. Voting issue number 2 for the affirmative is stock issues upheld. Now, their last points talking about coming from the negative, they talk about how it's not essentially it's not an electronic surveillance law because 3 of the 4 laws that we're changing aren't electronic surveillance. First of all, we see no evidence of that in the round. But furthermore, they drop the other 2 ways where actually electronic surveillance topical. Talking firstly about how it's authorized, the NSL itself is electronic surveillance law, and how the info collected is all electronic. As we can clearly see under this point, we are absolutely reforming our electronic surveillance law because we're actually affecting both the data and the tool itself. But additionally, we can see that the only point at which we're actually affecting the policies is through our electronic surveillance law. So we're absolutely topical under this point. Let's take a look at the third voting issue. Voting issue number 3 is unconstitutional. Voting issue number 3 is unconstitutional. We can actually see that through 3 ways, and it's highlighted by the 3 harms of the affirmative team. The first of which is discussing the First Amendment violation in accordance with the gag orders. Now, two courts have ruled that this is unconstitutional, side with the advocacy at the end of the round. Furthermore, if we take a look at the separation of powers argument, we can clearly see that, again, their judges have ruled their opinions on this issue. The separation of powers is a violation of the Constitution. And finally, if we take a look at the third harm, discussing the idea of oversight, we see the fact that the FBI currently has no authority over them. They're using the gag orders inappropriately. So as we can see, the companies cannot disclose this information. They're being put on by a gag order which is completely unconstitutional. They're completely unnecessary to have for a national security reason. There is no reason to keep national security letters. Thank you very much.
Thank you. Ditto. Thanks. Thank you. Thank you everyone for judging.
In front of the stage or on the stage?
Let's go on.